these disputes can be avoided through clear written agreement before creative work begins. Our guest on the program last week, Ijeoma Egbunike, the Director of Public Affairs at the Nigeria Copyright Commission headquarters in Abuja, was able to answer as many questions as were sent to the program that was last week. Still last week, our question for the week, the copyright question for the week was, who owns copyright? Is it the person who created the work? Is it the person who paid for the work? It depends on the circumstances and the law. Most importantly, on our Did You Know fact for last week, we established that buying a painting, purchasing a photograph, or paying someone to create a work for you does not automatically mean you own the copyright. In many cases, you own the physical item or have agreed the right to use it, while the copyright remains with the creator, unless the law or a written agreement provides otherwise. That's why understanding copyright ownership is so important. Now, moving on to where we paused last week, my special guest on the program is still very much with us and is still very much available, Ijeoma Egbunike, the Director of Public Affairs at the Nigeria Copyright Commission, NCC, all the way in Abuja. Good morning and welcome to Copyright Connect for today, the 14th of July, 2026. It's good to have you again.
Thank you so very much,
right.
Tolu. I'm so glad to be back.
In fact, I'm so elated because where we stopped last week was very, very important and very interesting. So we're just going to continue from there. And due to popular demand, we will quickly revisit our discussion on joint ownership of copyright materials and content. Ijeoma, are you still there?
Yes, I'm here.
All right. You're listening. You're following us. I said due to popular demand, a lot of people called that they want us to revisit that issue, that you need to re-explain to them what happens when two or more people create a work together.
Okay. Thank you so very much, Tolu. I'm happy to be back.
We're so glad to have
last
you.
Week, yes, thank you. Last week, we talked about the issue of joint ownership.
Yes.
And that is when two or more people make creative contributions to a work. And those contributions cannot easily be separated. So they may be regarded as joint owners. And in such a case, or in such cases, they are generally regarded as co-owners of the copyright, unless they have agreed otherwise.
Okay.
The law also recognizes that co-owners may decide how their rights, how their income, that is the income from their work, are shared.
Okay.
Hello?
Yes, we're listening. We are listening.
So, yes, so it goes to say that two people can co-author a work. And that is because two of them brought contents to bear. And then that from the beginning of the project, they have agreed that we want to do this. We want to create this work. I will bring this content. You bring this. Maybe you bring this amount of money. In the area of publishing, we will do this. And then when the income starts flowing in, when the royalties start coming, this is how it's going to be shared. So it means from the beginning, there should be an agreement on how we raise the content, how we go about publishing our work, if it's literary, how we go about singing a song, if it's music, and all of those. At the end of the day, both are regarded as joint authors, joint creators. And therefore, none is expected to take any decision without recourse to the other. Yes.
Now, that is, I'm looking at a scenario where they have a written agreement. What in case of where they do not have a written agreement, it was just verbal, word of mouth, and then something happens tomorrow. I decide I want to do something with that work, and the other party disagrees, and they bring it to your table.
That's going to be rather unfortunate because in owning works, agreements must be documented. Agreements are supposed and must be documented to be effective when issues arise.
Agreements
So when it's not documented,
must be documented.
when it's not documented, if it's just by word of mouth, somebody may deny the other person. So, but when it's documented, it becomes binding on both.
On both parties. And then if
Yeah.
such a case is brought to your attention, how would you address it? Because we have
Well,
people.
the first, yeah,
We have people.
yeah, I'm listening. I'm
Yes, we
listening.
have people from some of the comments we have received after the last edition. Some people have actually said that they are in such situations. If such a case is brought to your table, how are we going to address it?
Well, I think we would like to see the terms of agreement of those people. So we want to see the terms of agreement. You don't start a business, you don't start something without agreeing and documenting it formally. So that is how we will start, and then we'll take it from there.
Another question people ask is whether copyright can be sold or transferred. We hinted on that last week, but we didn't, because of our time, we couldn't go deep into it.
Yeah. Thank you very much. You know, last week we talked about copyright assignment and licensing. So we said, first and foremost, that the original owner of the work is the person that created it, the person that thought, the person whose idea the work is, and who expressed it in some form or in some format.
Or the other.
That person is the original or the first owner of work. But we did say that there could be an assignment of copyright or exclusive license, which must be in writing. So if it's my work, I'm the copyright owner, and you want to buy over my work, let me use the word buy over my work, it will be documented. I could assign a chunk of my right. Most times it's not all of the right. I could assign or transfer some rights that the law or the act has given to me as the owner of the work. And that is, you know, those rights as going public, those rights as, you know, like we've discussed before, that the act gives to the owner.
Provides for such.
Yes. So if you are going to take it over, or if we agree that I'm going to assign part of my copyright to you, then it means it is an exclusive license and it must be in writing. But I want to say here that in copyright, there are different rights. There is exclusive rights of the owner, and then there is the moral rights of the owner. So for the, or rather, economic right of the owner and the moral right of the owner. And the economic right is such that it's easily transferable by way of assignment or exclusive license. Now, the moral right is one that has to do with the right of attribution, that it is my work, and for each time it is mentioned, my name must be mentioned as the person that created that work.
Okay.
So that in itself is not transferable.
Okay. Meaning
That
my
is
work.
The moral is not easily transferable. The economic right I can't transfer, I can't assign to another person.
That's outrightly buying over my work. But every time you use it, my name has to come.
Yes, I retain my moral right as the owner of the work.
That's beautiful. I really like that. Now, one question that came last week as we were about rounding off. This question says, Ma, I am a presenter. I won't mention my name because I'm still working. And I work in a radio station.
All right.
The person said, I Okay, I have the. I'll try and read it because the question didn't is also straightforward. I am
Okay.
at a radio station, but I want to carry my program to another station. But they said the program does not belong to me. Please, who owns that program? Am I the one or the radio station? Do you get it?
Yeah, thank you very much, Tolu. I'd like to say that there is no single answer to this question, and that's because it depends on how the program was created and the terms of the person's employment or contract. And now, under Section 28, subsection 1 of the Copyright Act 2022, copyright generally belongs to the author or creator of an original work. We've said this over and over again, unless there is an agreement stating otherwise. However, Section 28, subsection 2 of that Act provides that where a work is created under a contract of service or contract of services, or in the course of employment by a government, ministry, department, agency, we said all of those last week, that the copyright will vest in that employer unless, underline, unless there is an agreement to the contrary.
Prior.
And so, yes. So the person that is asking this question says she has developed the program. But if that program had been developed independently before joining the station,
okay,
and then merely presented it there under an agreement
I hope the person is listening.
Yes, I hope the person is listening. There should have been an agreement if the program was developed independently, and that is even before the person joined that station, but that there's an agreement that they will allow, the program to be presented on that station, and then there will be retainership of ownership.
Okay.
So it means that person will still be seen as the copyright owner.
Okay.
However, if the person had created that program as part of the person's responsibilities and duties as an employee, of that station. Yes, using, as it were, the station's resources, and being done under the contract of employment, the copyright or certain rights in the program belongs to the station. Okay. Unless, like I said, there was a contract that to,
prior to otherwise. That engagement. Now, another question that we got, this one is very tricky. Please, madam, I really want to know this. I am a PA to a managing director, and during the packaging of his autobiography, I wrote everything. In fact, he was just telling me the stories and I was the one writing it. But when the work was done, I did not get any credit. I am feeling bad now because the book has generated a lot of millions for them, but I am blacked out. If I sue, do I have a case?
Well, my first question is an interesting question.
Seriously.
Which involves it involves both copyright and some employment issues. So now my question will be, at the point of being hired as this fellow's personal assistant, were there discussions around if this kind of thing happens, if this happens, how do we go about it? Still talking about agreements.
The person did not indicate anyway. But
the person
if the person is listening.
Yes, but if the person is listening, let me try to answer this question.
Okay.
An autobiography, as we all know, tells the life story of a person.
While the person is still alive.
Whose experiences and all of those are being recorded. So if the person that is asking this question merely wrote down, edited, organized the MD's narrative as part of his or her official duties, he may still be regarded. No, we're not talking about the managing director.
Yes, of that
the
organization.
The managing director, yes, It is his story. He narrated it.
Yes.
But this other fellow really wrote it down as part
For him.
of his work with this man's PA.
Yes.
The MD.
Yes.
In this instance, is regarded as the author, copyright owner
Of the work.
Like I said, it also depends on the circumstances and agreement around the employment. However, if the person that asked this question made substantial, original, creative contributions that goes beyond transcription, editing, writing down what somebody is dictating, or there was an agreement recognizing the person ab initio from the beginning of the employment as a co-author, if this kind of a thing comes up, then the position will be different. But from the questions you're asking, the MD owns this copyright. As for not receiving credit, that also depends on the nature of the person's contribution and any agreement between the parties. But from what she said, her contribution was
just
listening,
transcribing, typing,
listening, writing down, transcribing,
and typing.
That is all. And typing. So,
There's
without
no
further
case.
ado, the copyright belongs to the managing director in this instance. Yes.
Okay, so we can just say she's just feeling entitled.
Yes.
Maybe
I'm feeling
because
bad
of
now
the money
because the book is
generating a lot of. Okay.
Generating a lot of money.
I hope you're listening. Whoever wrote that question, your question has been answered and really makes a lot of sense. Your explanation makes a lot of sense. This next question says, I want to ask the NCC madam, I went to take my pre-wedding pictures at a photography studio. Some months after, a lot of people started telling me they saw my pictures on a billboard advert of the studio. They're actually a very big company. I'm about to take action. Please advise me on what to do.
Yeah, Tolu, let's take it from our discussion of last week.
Yeah.
Remember we said that the photographer is the original owner of
the work.
His photograph, the work. Now, we also talked about works that are commissioned by some other people. In this instance, I would like to say that the question involves both copyright and other legal rights. I'll explain. Like I said, generally, the photographer is the first owner of copyright in the photographs under Section 28, subsection 1 of the Copyright Act. Unless there is an agreement stating otherwise. That's why we always emphasize on agreement, and most times documented agreement. Yes, you're the photographer, but in this instance, it is me, it's my party, it's my image. I have commissioned, I've paid you to do this. So there has to be an agreement from the beginning that when you take these pictures, I have the right to do some things, and then you are not allowed to do certain things because I'm commissioning you. However, like I said, Section 28, subsection 3 of the Copyright Act recognizes that where photographs are commissioned for private and domestic purposes, the person who commissioned them has a non-exclusive license to use them for non-commercial purposes, and also has the right to restrain the publication, exhibition, broadcasting, public distribution, subject to the agreement between the parties. So what am I trying to say? From the beginning, I am the one that I've commissioned. Yes, I've commissioned, but I have a non-exclusive usage over those pictures. I am not to use it commercially because somebody owns the copyright ab initio, and that is the photographer.
Okay.
But since I've commissioned it, I have the right to use it, put it, show people, do all of those things that would not be economic, that would not be commercial. Then you as a photographer, yes, you own the copyright because you took the pictures. It's your copyright, is your work, is your creativity. But I'm saying, don't go doing this. I wouldn't want you to use my pictures in certain ways. So these are agreements that people should make from the beginning.
Before commissioning.
Before going into the studio and taking all of those pictures. Therefore, if the person that is asking this question never authorized the studio to use their photographs for commercial advertising, because using it on the billboard is commercial advertising.
Definitely.
So the person should first review any agreement or consent form they signed. Whatever they agreed on and documented must be reviewed. If no such permission exists, the person have grounds to challenge the commercial use of their photographs and should seek legal advice. That would be my answer to that question. The NCC, we're here, we can provide further guidance on the copyright aspects of that matter.
All right.
But like I said, summarily, the photographer, it is his copyright. But he has been commissioned, he has been given money to do this. So there are limits to his right now. There are things he's not supposed to do. Yes.
All right. The last question.
Commercial advertising of those pictures. Yes. All right. Thank you.
The last question says, please give me a brief about the NCC Copyright Commission, its mandate, the location of its offices, and other important details. Can you quickly do that in 2 minutes?
Wow. NCC. The Nigerian Copyright Commission is a federal government agency responsible for the administration, for the regulation, for the protection, for the enforcement of copyright in Nigeria. It operates under the Copyright Act 2022 and works to promote creativity, to protect the rights of authors, musicians, filmmakers, publishers, software developers, broadcasters like you, and other creators.
Okay.
Our major responsibility include administering and enforcing the Copyright Act 2022, all of those things in the Act. We have the mandate to administer and enforce them, to protect copyright owners against piracy, infringement, to investigate copyright offenses and support enforcement actions, promote public awareness as we're doing now, and education on copyright, as well as international copyright agreements and relationships. We also regulate collective management organizations. We have CMOs. CMOs are the collective management organizations that are in charge of differentials of copyright. Some are in charge of music. The Repronig is in charge of literary.
Okay.
The AVROS is in charge of the audiovisual zone. For music, we have the MCSA. So these are CMOs that we give license and we regulate. We also facilitate copyright registration. We maintain copyright records for right owners. Then we also provide the services of mediation and other dispute resolution services in appropriate cases.
And I think now we will have to give this person your contact details so he can mail you and you give the person more information about the mandate of NCC, because our time is already fast spent. Quickly, let me go to our social media page. This one says, hello, this is an innovation and on copyright. I would like to connect with Madam Ijeoma Egbunike or any NCC official and get insights on NCC's role in copyright protection. So many messages I won't be able to take on the program this morning. But in case you need to contact the NCC, the Nigeria Copyright Commission is there to help. For information and guidance and support, email info@copyright.gov.ng. Phone numbers +234 901 900 1400, 234 901 900 1401. You can also send message to STOP Unit Hotline, WhatsApp only, 081 3745 9027. Thank you for joining us on Copyright Connect. Be sure to tune in next week for another engaging discussion on copyright. Many thanks to Ijoma Egbunike, Director, Public Affairs, NCC, Nigeria Copyright Commission. Thank you so much for joining us.
Thank you very much. Thank you.
All right. Okay, next time it will be another time out on the program Copyright Connect on Oxygen FM 96.9. My name is Tolu Adepoju. See you next week.